Bugünün teması olan kişisel verilerin korunması ışığında klinik araştırmalar konusuna geçiyoruz. Bu bölüm 3 konuşma bir panel içeriyor. Bunları avukat doktor Elvan Sevi BOZOİ yönetecek. Önce size Sevi BOZOİ'nu tanıtmak istiyorum. Doktor Sevi BOZOİ 2002 yılında Ankara Hukuk Fakültesinden mezun olmuş ve 2004 yılında İstanbul Bilgi Üniversitesi'nde ekonomi hukuku alanında başladığı yüksek lisansını Erasmus programı kapsamında Utrecht Üniversitesi'nden de aldığı derslerle 2006 yılında tamamlamış. Daha sonra da İstanbul Kültür Üniversitesi'nde kamu hukuku alanında yürüttüğü doktora çalışmalarını 2019 yılında Uluslararası Anlaşmalar Işığında Rüşvetle Mücadelenin Yeni Boyutu ve Tüzel Kişinin Ceza Sorumluluğu adlı tez çalışmasıyla tamamlayarak doktor unvanını almıştır. Doktor BOZOİ 2016-2019 yılları arasında Uluslararası Şeffaflık Derneği Yönetim Kurulu üyeliği yapmış. 2014 yılından bu yana da Uluslararası Barolar Birliği Yolsuzlukla Mücadele Komitesi'nde üye sorumlusu, Doğu Avrupa Bölge sorumlusu, Çeşitlilik ve Kapsayıcılık sorumlusu, Yaşam Bilimleri ve Sağlık Komitesi'nde de bütçe sorumlusu olarak görev yapmaktadır. Sivil toplum hareketlerinin güçlendirilmesi gerekliliğine gönülden inanan Doktor BOZOİ, Klinik Araştırma Derneği Yönetim Kurulu üyeliği yapmaktadır. Halen de yönetim kurulumuzun üyesidir. İlaveten nadir hastalık alanında faaliyet gösteren İlaç Firmaları Derneği'nin kurucu yönetim kurulu üyesidir ve Yönetişim ve Mevzuat Derneği'nin de kurucu yönetim kurulu üyesidir. Hala aktif olarak bu görevlerini sürdürmektedir. Doktor Sevi BOZOİ İzgi Avukatlık Ortaklığı'nın kurucu ortaklarından olup 20 yılı aşkın avukatlık yaşamı süresince mesleğini fikri mülkiyet, rekabet hukuku, teknoloji, regülasyon ve uyum, iç soruşturmalar ve kamu soruşturmaları, uluslararası alanda yolsuzlukla mücadele ve veri koruma alanlarına odaklanmış bir şekilde sürdürmektedir. Sizlere Sevi BOZOİ'nu takdim ediyorum konuşmasını yapmak üzere.
Çok teşekkür ediyorum hocam bu kapsamlı takdiminiz için. Bugünkü oturumumuzu açabiliriz. Herkese merhaba, ben avukat doktor Elvan Sevi BOZOİ, Klinik Araştırma Derneği Yönetim Kurulu üyesiyim. Bugün kongremizin ikinci günü, bu ikinci günün ikinci bölümünde klinik araştırmalar ve veri koruması konusunu ele almaya karar verdik. İki bölümden oluşacak olan bu oturumumuzun birinci bölümünde Avrupa'dan ve Amerika'dan konuşmacılarımız var. Kendilerini birazdan ayrı ayrı tanıtıyor olacağım. İkinci bölümünde ise daha çok Türkiye uygulamalarına ve Türk hukukuna odaklanacağımız bir panel olacak. Burada da çok değerli katılımcılarımızla sizlerden gelen soruları da ele alarak kendi içimizde de birbirimize sorular sorarak konuyu ilerletmeyi planlıyoruz. Şimdi yabancı konuşmacılarımızı dinlemek üzere kendilerine bağlanalım. Welcome everyone. It's a pleasure to hosting you in our event of today. This is the second day of the fifth annual virtual meeting of Clinical Trials Association in Turkey, and I'm very happy for having all of you and have an ability to discuss on data protection and clinical trials related issues all together. And this is a very complicated area also in Turkey. And this will be a session for all of us to provide our legal perspectives. We are all lawyers here. The most of the audience is not legal people, but they are having those practical difficulties in designing their clinical trials. Hopefully, we will be giving them a legal insight at the end of this session, on how to coordinate the problematic areas and the issues that they confront with from a legal point of view. I would like to give the word to Jérémie, and we have Thibaut and the Faraz on the line today. I'll be introducing each of you before your presentations, if I may. Jérémie Doornaert is working with Simmons and Simmons in Belgium. He's practice focuses mainly on data protection matters and complex data processing activities, especially in the life sciences and technology industries. His experience also includes working in major pharmaceutical and medical device companies as a part-time in-house counsel for years. And Jérémie will be giving us, as I mentioned, the high-level insight about the EU data protection law and interaction of it with the evolving clinical trials legislation. And please, Jérémie, we are going to have your thoughts.
Thank you for the kind introduction. I'm going to share my screen. I hope that you will see it. So good afternoon, everyone. This afternoon, I'm going to present you the rules governing clinical trials and data protection in the EU. So in the EU, we have two key instruments for clinical trials and processing of personal data. First, you have the Clinical Trial Regulation, or CTR, which was adopted in 2014 and which governs since the beginning of this year the regulatory aspects of clinical trials conducted in the EU. It was already adopted in 2014, but only applies since January of this year because the authorities had to create and implement a specific portal for dealing with the clinical trial and databases. The purpose of that regulation is to assess and conduct clinical trials according to harmonized standards across the EU. But unfortunately, local laws still remain relevant in some cases because the regulation has left to the member states some areas to take specific rules. So the harmonization is not exhaustive, meaning that you will have to take into account clinical trial regulation when doing a clinical trial, but also some local laws where the clinical trials will be conducted. The second key instrument is, of course, the famous GDPR, the General Data Protection Regulation, whose purpose is to give control back to the EU citizens on their personal data and to harmonize as much as possible the data processing in the EU. Like for CTR, unfortunately, there are also some open clauses which allows member states to take specific rules on certain topics, including, for example, for scientific research. So it's not very convenient, but when you do scientific research in the EU, you will have to pay attention to the GDPR, but also sometimes to local law. As you know, the GDPR imposes significant sanctions in case of breach. So it's very important to bear that regulation in mind when conducting clinical trials and any processing activities in the EU. So most of you are not located in the EU, so you have to wonder, why do we have to speak to you about those key instruments today? You have to wonder whether and in which circumstances the CTR and the GDPR will apply to your activities. For the CTR, the territorial scope is quite clear because it applies to all clinical trials conducted in the EU. So it's very broad. As soon as a sponsor, even located outside of the EU, conduct a clinical trial in the EU, you will have to comply with the CTR. And to know if your clinical trial falls within the scope of the CTR, you should also check the different definitions of the CTR, which gives explanation on what is a clinical trial and what is a low interventional clinical trial, which both fall within the scope of the CTR, which is not the case, by the way, of non-interventional studies. For the GDPR, the Article 3 of the GDPR defines the territorial scope according to two different criteria. The first criteria is about the establishment. If an organization has an establishment in the EU, and if that establishment processes personal data in the context of its activities in the EU, it will have to comply with the GDPR. And as the text of the GDPR is not very clear about what is an establishment, the European Data Protection Board, the EDPB, has adopted some guidelines to help the organization to understand whether the GDPR applies or not to their activities. And regarding that establishment criterion, the EDPB has explained that an establishment implies the effective and real exercise of activities through stable arrangements. And the threshold of a stable arrangement is very low. You do not have to have a branch or a subsidiary in the EU for the GDPR to apply. One single employee or an agent in the EU is sufficient for the GDPR to apply if there is a sufficient degree of stability. So it's a very broad application of the GDPR. The second criterion of the territorial scope of the GDPR goes a step further because it says that it also applies to non-EU entities. So even if you do not have any establishment in the EU, the GDPR will apply if you monitor the behavior of persons located in the EU. And according to the guidelines of the EDPB, monitoring or regular reporting of an individual's health status can be an example of monitoring in the meaning of that article. So if a sponsor outside of the EU is conducting a clinical trial in the EU, it is very likely that the GDPR will apply. And I think that Thibaut will give you further explanation about the position of the different DPAs, data protection authorities, in that respect. It's important to note also that the material scope of the GDPR is also very broad. Personal data is a very broad concept, and as soon as you process personal data, you fall within the scope of the GDPR. And personal data, it's really very, very broad. It's any information which relates to an identified and identifiable living individual. So it does not apply to dead people, except in some specific country like France, for example, but it applies to any information that allows you to identify someone, even if you cannot directly identify that person. There is also a specific definition for health-related data, which is, of course, very important for clinical trials. And it's important because the GDPR imposes specific conditions to process health-related data. Another concept which is important is pseudonymized data, because a lot of sponsors outside of the EU think that GDPR is not applicable to them because they only receive coded data or pseudonymized data, because and they do not receive identifiable data of an individual. But unfortunately, for them, pseudonymized data is considered as personal data under the GDPR. So even if a sponsor located outside of the EU receive personal data, pseudonymized data or coded data, the GDPR will apply to the processing of that activities, provided, of course, that the territorial scope is met. It's only truly anonymous data that are excluded from the scope of the GDPR. And to have truly anonymous data, it's actually very difficult. The threshold to obtain a truly anonymous data is very difficult to achieve. And there are also some guidelines, an opinion actually of 2014 on anonymization techniques, which explain how robust anonymization techniques must be to comply with the anonymity, with the concept of anonymous data. Again, the threshold is very, very high. In order to understand the obligations of companies, organizations, and institutions outside of the EU under the GDPR, it's very important to define the role of that organization in the framework of clinical trials. So you have basically three different kinds of actors under the GDPR. One, the most important, is the controller. The controller is the person who will determine alone or jointly with others the purposes and the means of a processing of personal data. So there are five key elements to assess to decide whether a stakeholder is or not a controller under the GDPR, and it's important to determine beforehand because it is on the controller that most of the obligations of the GDPR will rely. So it's important to identify who is the controller of the processing so that you can know who must comply with most of the obligations of the GDPR. You also have the concept of joint controllers under the GDPR when different parties determine jointly the purpose and means of a processing. This must be assessed a factual basis, but the EDPB, the European Data Protection Board, the European Data Protection Authority, has provided some guidelines to help you to define, in the case of clinical trials, whether you are a controller, a joint controller, or a processor. And if there is a collaboration, for example, between a sponsor and a principal investigator in a clinical trial, if there is a collaboration to draft the study protocol, it is likely that the parties will be joint controllers under the meaning of the GDPR. If the study protocol was only drafted by the sponsor, the investigator is likely to be considered as a processor and not a controller. And a processor has much less obligations under the GDPR than a controller. The investigator, of course, even if it is only considered as a processor, remains a controller for the purpose of patient care. Because very often, when you have a clinical trial, you have a treatment of a patient behind that clinical trial. And for that specific processing, for the processing of personal data of the patient for his treatment, the investigator will remain the controller of his data. And so in a clinical trial, you can have an investigator acting as a controller for the processing relating to the treatment of his patients, a joint controller if he has contributed to the drafting of the study protocol, and a mere processor if the investigator has only executed the instructions of the sponsor regarding the study protocol, for example. And finally, I said that there are three actors, the controller, the joint controller, and then the processor, which is actually the person who will process his personal data on behalf of the controller upon the instructions of the controller. And when you have that relationship between a controller and a processor, you have to bear in mind that there must be, under the GDPR, a contract between those two persons, a contract between the processor and the controller. And that contract must include certain mandatory provisions that are provided in the GDPR. So it's very important to identify all the persons intervening in a clinical trial to know which obligations will apply to those persons. And finally, on that question, I would say that the EDPB guidelines that you see on that slide provides a flow chart to help you with the concept in practice, to guide you to determine whether a relevant stakeholder is a controller, joint controller, or a processor. So clinical trials imply, of course, the processing of personal data, general personal data like the name, the date of birth, of special category of personal data like health-related data, for example. And of course, as all clinical trials imply the processing of personal data, there are some references to the GDPR, to the data protection in the CTR. And so there is a link, there is an interplay between the two key instruments of the EU. And to help the organizations to understand the interplay between the two instruments, the European Commission has adopted some Q&A, question and answers, in 2019, which is a very interesting document because it provides the organization with a basis for a GDPR-compliant clinical trial. So I invite you to look at those Q&A to have some interesting information about the interplay between the two instruments, because, for example, it recalls the obligations of the controller under the GDPR, like, for example, the obligation to provide information to participants about the processing of their personal data, sometimes the obligation to appoint a data protection officer, the obligation to facilitate the exercise of the patient's rights, the individual's rights, and also the obligation to determine a legal basis. To process personal data, for whatever processing, you have to determine a legal basis, a valid ground to process those personal data. And the European Commission has made a distinction between the processing for a primary use of health-related data and for secondary use. For the primary use, when the processing is related to the execution of the clinical trial protocol, there is a distinction to be made between different purposes. If you process the personal data for reliability and safety purposes, you will be able to process those personal data on the basis of a legal obligation. So you are fully covered. If you process those personal data for research activity, there is no legal obligation. So you will have to identify an alternative valid ground to process the health-related data of the participants. And there are three options. One, public interest. Two, legitimate interest. And three, the consent. And traditionally, sponsors, pharmaceutical companies, medtech companies relied a lot on the consent. But the European Commission has highlighted in that document that sometimes, and even very often, consent may not be the most appropriate valid ground to process the personal data. And implicitly, the European Commission says that maybe that the sponsors, the pharmaceutical companies, should turn to other option, alternative legal grounds to process the personal data. You have the primary use, and then you have the processing for the secondary use, which is a processing outside of the protocol, but for research purposes. In that case, there are some conditions to process the personal data for secondary use. First, fortunately, you have a presumption of compatibility of the purposes. So there is a presumption that the processing for secondary use will be compatible with the collection of the personal data at the origin of the project. So that's a good thing, but that does not mean that you do not have to comply with all the obligations of the GDPR. The other obligations of the GDPR, like the information of the persons, the obligation to have a valid ground, like I mentioned on the previous slide, the necessity and the proportionality of the processing still remains. So you have to comply with the principles and obligations of the GDPR. And you can, for secondary use, opt for the same legal basis as on the previous slides. I will show you on the right column. You have the same three options for secondary use for research activities: public interest, legitimate interest, and finally, the consent. And about the consent, that will be my last word. The concept of the consent has been subject to very stringent conditions under the GDPR, meaning that to have a valid consent, you have to comply with the requirements of the GDPR. You cannot just ask the consent, a yes or no, to process the personal data. You must provide some information. The consent must be explicit when it relates to health-related data. And it's also not possible to switch from one legal ground to another legal ground. If there is a problem, if you relied on the consent and there is a problem with that consent, it will be unfair, according to the data protection authorities, to switch and to opt for another legal ground. So it's very important from the beginning of your project to choose the right legal basis before the processing takes place. That's the first thing to do. The first thing to do is to determine the roles of everyone: controller, joint controller, processor, and then to identify the valid legal grounds for the processing to take place. I don't think that I will elaborate a lot more on the consent, because I think that Thibaut will cover that in his speech. But it's maybe one last thing. It's important to bear in mind that there is no exemption for the right of withdrawal of the consent. So if you rely on the consent of someone, you must give that person the opportunity to withdraw his consent. And if that person withdraws the consent, you can no longer process the personal data after the withdrawal of the consent. And that can have a significant impact on the clinical trials results in some cases. So that's why it's very important to rely on a valid legal basis and to think about the right choice of the legal basis. And maybe one last word about the consent is the fact that you cannot mix the consent to participate to the clinical trial and the consent to process the personal data. The two consent must be separate. If you rely on the consent to process the personal data, you have to obtain a separate consent than the consent of the participant to participate to the clinical trial. There is a regulatory aspect of the consent to participate to the clinical trial, and there is a data protection aspect, which is another consent to process the personal data of that person. That's it for me.
Thank you very much. This was really giving us the legal framework, and I have even a lot of questions. I'm sure we will have further questions from the audience. Later we can touch upon them. But now I would like to give the word to Thibaut for him to continue where you have left. And Thibaut Dulas is a lawyer also working with Van Belbelis in Belgium. And he's very much experienced also in data protection related issues, but he also deals with technology, competition law, intellectual property law aspects. His practice focuses on life sciences industry, and he will continue explaining us further about the EU law and GDPR and their interaction on clinical trials. Thank you.
Thank you very, very much, Sevi, for the introduction. I'll also try to share my slides. Please bear with me. Okay, can you see my screen?
Perfectly.
Okay, and just the introduction slide. That's great. So thank you again for that introduction, and thank you for having me on this conference, where I'll try to speak a little bit more about data protection in the EU and clinical trials. There's much more to be said. So I'll build on the excellent introduction of Jérémie, and I'll try to address maybe from a more practical perspective some issues that we often see. To do that, I'll re-emphasize some of the key concepts under GDPR. I'll highlight some attention points and try to give you a flavor of what in practice, how we try to apply these the GDPR rules, and then to end, maybe give a perspective looking forward where we can see maybe some new solutions or rooms for improvement. So on the legal framework in the international context, I think it's important to note this special position that the protection of personal data has in the EU, and that's a stark contrast with some other countries. In the EU, the protection of personal data sits quite high in the order of legal rules. It's considered to be a fundamental right, and that's quite important in situations such as balancing with innovation, research, health purposes, to know that specific position of data protection as a fundamental right. So I think that's important to note as a starting point. Then on the territorial scope, I will not repeat what Jérémie already excellently presented. Important to note that even if a sponsor is established outside of the EU, if he has set up clinical trials using hospitals in the EU, it is very likely and better to assume that the GDPR will apply to those processing operations. Then again, I must echo what Jérémie already has said. An important concept and something that we see that people from outside Europe, but even people in Europe who are not maybe experts in data protection struggle with, is how broad the concept of personal data really is. So it's not only direct identifiers, but it also includes any information relating to a data subject. And it also includes, importantly for clinical trials, pseudonymized data. So what are those? Those are encoded information that can no longer be attributed to a person, but you need additional information. So for example, if we talk about patients, we'll remove the name of the patient, give them a patient number, and then we keep the database that links that patient together with the patient number or the information that we have about that patient somewhere safe to avoid any unwanted re-identification. So that's what we have often with clinical trials. That's also considered to be personal data, even if that step, which makes that link between the person and the information relating to the person a bit more difficult, provides some safeguards that we will see can be helpful in confirming with the GDPR. It's important to note that pseudonymized data is still personal data, still falls under the GDPR. Again, repeating what Jérémie already said, if you want to escape GDPR, you have to truly anonymize data, and that can be very, very difficult to do in a research context. So if you want to do that, you'll have to be able to demonstrate that this information is truly anonymous, and the bar is quite high there. So then moving on to next key concept, personal data. There's different types of personal data. Some are more sensitive than others. Under Article 9, there's a specific protection for what we call sensitive categories of personal data. And that protection is that in principle, processing such data is prohibited unless you can rely on one of the derogations. So one of the reasons that would allow you to still process as personal data. I've listed the most relevant for clinical trials or in the context of health research here, and I'll come back to them a little bit later. Important to note about those special categories that includes categories such as health related data. So health records will always be special data, and also genetic data. Just maybe as a short side note, genetic data poses specific issues under data protection rules for different reasons. First question is genetic data. To whom does that data relate? We've seen the broad concept of personal data. It just relates to an individual. Genetic data can reveal information not only about maybe the patient or participant in a trial, but also about the relatives. If we think about genetic diseases, for example, that can be relevant there. So if we're dealing with multiple data subjects, that's can pose some significant challenges in ensuring compliance. But also in terms of anonymization, there's an open question whether we can truly anonymize genetic data. A recent opinion of the European Data Protection Board of February last year says it's safer to assume that it's not possible. So strongly recommends to consider genetic data always to be personal data, and so always have to comply with the GDPR. So then moving on, another important principle and an innovation when the GDPR was introduced is the concept of accountability. And what does accountability mean? Well, it means two things. First, it means be responsible when you handle data. That includes designating a person who's responsible. So in this case, it's often going to be a data protection officer. What supervisory authorities also like to see is that management of an organization takes ownership, is aware of how the organization is protecting personal data. Obviously, you have to educate employees and take some additional steps to really be responsible. But being responsible and being compliant is not enough. Under the principle of accountability, you don't only have to comply, but you have to be able to demonstrate that you comply. For that, you can use policies, procedures, try to create a paper trail. So look at your contract, your clinical trial agreements, make sure that they include all the relevant clauses to show you compliance. Later on, I'll talk briefly about the opportunities of data protection impact assessment as an accountability tool as well. So those were some key elements that I think can be relevant. If now we turn to some attention points and some issues that we often encounter. First, again, Jérémie explained very well the different roles, how to define them. Important to note, these are definitions that follow from the law and are factual analysis. So whatever you decide under the parties is not so relevant as the factual assessment. Won't repeat the definitions there, but just point out that in practice, it's very difficult. There is a guidance, again, I think Jérémie has referred to it, which seems to propose whether on the question of a principal investigator can be a joint controller or rather a processor together with a sponsor. that proposes the criterion. Did the investigator participate in drafting the protocol? If he did, he's probably joint controller. If he's not, and in multi-center studies, a lot of investigators will not really have a significant say about protocols. They should be a processor. Seems very simple, but in practice, this advice, there are some shortcomings with it. It doesn't take into account the important decisions that any investigator can take for the participant of the sites for which he's responsible. Also, the ethical rules, which emphasize that it's very important that the investigator is independent. Under this clinical trial regulation, the investigator will have direct obligations there. So all these elements are a bit uncomfortable with the qualification of processor. And for that reason, under prior to this guidance, we saw that a lot of contracts or a lot of relations were more seeing investigator as a controller rather than a processor. So result of that is that if we look at the map of Europe, and here we applied the guidance that we were aware of, where there are national positions on should investigator sponsor be joint controllers, independent controllers, processor, and controller. We see that some countries like France, there is a clear guidance or decision by the CNIL, the French authorities, which says, well, the investigator should be regarded as a processor on behalf of the sponsor. There's other countries which still stick to a joint controller position that was more popular before. And then there's other countries like Spain where the national guidance sort of refers to investigator and sponsors as independent controllers. So the result is that we have a patchwork of legal positions that's very difficult to deal with. That has consequences for the contracts that you draft, because depending on the relation, you will need different clauses, but it also has consequences for data subjects, because depending on the relation, you will have different mechanisms on how, for example, they can exercise their rights. So first point to note where there's, I would say, room for further harmonization. Next element, if we look at lawfulness or the legal basis, again, relying on the excellent introduction provided by Jérémie, there are a number of options available. And as Jérémie already pointed out, there's not just one legal basis for the whole study as such, but you have to look at the purposes for which you're using the personal data at hand. Some processing operations pursue some legal obligations, and then you will be able to rely on that legal basis. For others, mostly the research as such, you may have different options, which can look appealing. There's always a discussion there about consent. Can we rely on legitimate interest? Should we rely on consent? There's a question, should the ethical framework and the ethical standards, which are very important in clinical research, they appear to favor consent. Does that mean that if we're doubting between these two legal bases, we should go for consent? The question has recently been answered, again, in the same advice of February last year by the European Data Protection Board, that says, well, you have to distinguish the consent, the ethics consent, which is required. Well, if we look at the reasons, why does ethics prefer consent? A lot of the ethics rules originate in a situation where people were included in studies against their will. So the consent, now we need it to make sure that that doesn't happen. So people are not included against their will or even without them knowing, but that is already covered by the regulatory consent, which is in the clinical trial regulation. And we have to distinguish the regulatory consent or the ethical consent from consent as a legal basis for the processing of personal data. And for the processing of personal data, for that reason, the EDPB says, well, you can choose. There are other options available, and maybe consent is not even going to be the most appropriate legal basis. Why is that? Well, first, and I think Jérémie again mentioned that you need separate consent. So you basically need two tick boxes, which is very confusing for patients. So is that good for patient protection? Not really, because if they fail to tick one of the boxes, they cannot be included in in the trial. There's also maybe some issues with free consent if they have incentives, whatever those may be, to participate in the trial. So for those reasons, maybe you can think about legitimate interests, and the EDPB confirms that that is a valid legal basis. So then moving on, as we said, legal basis is not enough if you're working with sensitive data like health data. You need an exception under Article 9. Again, there's different options. But as with the legal basis options, they are not always good because they can lead to different interpretation differences between what the sponsor thinks that they should rely on and maybe the opinion of the hospital or ethics committees. Moving on to secondary use, which has its own challenges. In the clinical trial regulation, we read that a consent is needed. And again, this is a regulatory consent for the use of data outside of the clinical trial. On the other hand, in the GDPR, there are a number of incentives or a number of provisions that facilitate further use of data. For example, there's a possibility to provide broad consent. GDPR recital 33 recognizes that in research, you may not be able to specify in the clear and specific terms for which consent is normally required the research purpose that you want to include. So you can use broader terms. Important, you still have to be as specific as you can be. So a blanket consent for any further research may not be valid. Then, and again, it's been mentioned by Jérémie, there's an exception to the purpose limitation principle. In principle says personal data which has been collected for one purpose can only be used for that purpose. There's an exception to that. If you want to use it for scientific research, that's deemed not to be incompatible with this initial purpose. But you have to take safeguards. Similar as we've seen Article 9, there's exceptions. There's an exception specific to scientific research, which again refers to this Article 89 that says you have to take specific safeguards that can be set out in EU or in national law. So some flexibility there, but unfortunately it refers to a large extent national law. So differences between the member states, not as harmonized as companies who operate clinical trials in different countries would want it to be. Then moving on to another hot topic, which has been a hot topic for the last couple of years because of different judgments by the Court of Justice in the EU, is international transfers. So if you're conducting a study in the EU and you may be transferring personal data, even in the encoded form outside of the EU, that's a transfer outside of the territory under Chapter 5 of the GDPR. You can't do that unless there is an adequacy decision, which, for example, for Turkey is not the case yet. So then you can adduce either appropriate safeguards or rely on derogations. Derogations, in principle, very difficult in structural transfers. There's still an open discussion whether there could be one derogation that applies in for some research. It's an open discussion, so not certain. Most cases you will want to rely on something which provide more security, and often that's going to take the form of standard contractual clauses, so the SEC. Important to note there that because of this case law of the Court of Justice, the European Commission adopted a new set of standard contractual clauses in 2021. And if your transfers of your trials still rely on the old SEC, you need to replace those with the new SEC by the end of this year. So that's becoming quite urgent, especially because the adoption of the SEC has become a little bit more tricky and may involve a transfer impact assessment. And so to ensure compliance again with that case law and the new guidance. Then moving on to the issue of transparency. So data subjects always need to be informed. There's different provisions depending on whether you receive the information directly from the data subject or not. If you are using an informed consent form, you're collecting the data directly from the data subject, the information will be included there. in that case, and as you probably all know, the informed consent form needs to be reviewed, approved, so that information that you provide to the data subject, which includes information about, amongst other things, the legal basis, international transfers, will be reviewed. And often that's where the discussion that I mentioned before about the legal basis, the opinion that an ethics committee may have that consent could be a more appropriate legal basis than the ones that you're proposing in the informed consent form, that discussion comes up, leading to you having to change the informed consent form, rely on different legal basis. Usually what we recommend there is try and push back. In some situation, especially with the new guidance, you can provide this guidance to the ethics committees. Sometimes they listen to it, they may accept your proposed legal basis, but it may also depend on national positions. If you don't, so that's in the situation of informed consent forms. If you don't obtain the information directly from the data subject, there could be some exceptions where you can't or you don't have to inform data subjects. But again, you may need to take additional safeguards to provide further protection for those people who may not be aware that their data are processed. Together with the transparency, you also need to inform data subjects about the use of their rights. Jérémie has mentioned the rights that data subjects have, which in practice with encoded data can also be a particular challenge. So then maybe final point, and which I think is there might also be some lack of awareness about, is data protection impact assessments under Article 34 of the regulation is an instrument that's required if there's a high risk to the right and freedom of individuals. Provision sets out some scenarios where it could be required. For example, if there's a large scale processing of special categories of data, so including health data, then European Data Protection Board provided more criteria, national authorities even more criteria. But to be brief about clinical trials, often there will be a large scale processing of sensitive data, and a data protection impact assessment will be required. So that means that it's an exercise when the study is set up, that you document how you make sure that you comply with GDPR and you've covered or you thought about what could go wrong, what could the impact be on data subjects and other parties concerned. A lot of people consider this to be an additional layer of red tape, but I would recommend to also see it as an opportunity for accountability. As we saw, it's one of the fundamental principles of the GDPR. So if you see this as an opportunity to show that even though there are some open issues, so some potential different interpretations, that by conducting the DPIA, you can document the choices that you've made. It can be a very helpful instrument if something goes wrong and you need to have a discussion with supervisory authorities. So with that, some issues or some, I would say, challenges in complying with GDPR when setting up clinical trials in Europe. Looking forward, do we see any improvement on the horizon? Well, maybe there are some signs. I would say there's a guidance from the European Data Protection Board that's been announced for a long time, has been postponed a number of times on research. And hopefully that can provide more harmonization. As we've seen, there's a need for harmonization on some of the very fundamental elements in research or clinical trials in particular, like the qualification of the roles of the parties, the appropriate legal basis, the safeguards under Article 89. Another instrument that's promising are codes of conduct, because the GDPR is a horizontal set of rules. It applies across industries, the same principles. It's difficult to adapt these principles to a specific sector, especially a regulated area such as clinical trials. And that's why the GDPR provides this possibility of adopting codes of conduct, which have to be approved. And then if you comply with the code of conduct, that's a means to show compliance and give you a little bit more comfort that you are in compliance with GDPR. There's been a number of initiatives initiatives. There's great challenges as well. If you remember the map of Europe that we show, member states have taken different positions to get the noses back in the same direction is proving to be very difficult, but there's some promising initiatives going on. So definitely something to look out for. And then finally, wanted to mention the European health data space. So what's the health data space? It's different things. It's an initiative in the context of the European single market, a single market for health data, but a component of the health data space would allow companies to have access to data that has been collected in that context, so sort of real world evidence, but you don't receive a copy of the data, you just receive access and you can do your research in the platform that's provided by the European health data space. And by that, you don't have to worry so much about the issues that we mentioned, such as legal basis or informing data subjects. So for some research projects, that could provide an interesting opportunity. It's still a proposal. I've briefly mentioned the status there. So again, something to follow up and look out for. That concludes my presentation. So I hope I provided you with better insights on the challenges we're facing and maybe a couple of ideas of how to resolve them.
Thank you very much, Thibaut. That was really enlightening after Jérémie. And now we have a better idea about the EU law and the implications. And I've added further questions on the question list to be delivered after we get Faraz's perspectives from the US law. And our last speaker is Faraz Sıddıqui. He's a Juris Doctor and also diploma of public health. And he's with Hyman, Phelps, McNamara, a law firm located in Washington, D.C. And he counsels life sciences companies with regulatory and compliance related issues with a long-term experience, and also works closely with clinical trial parties in dealing with clinical trial legal matters. So Faraz, now we are with you and looking forward to your presentation.
Thank you so much for that introduction, Sevi. Thank you to both the speakers for going before me and teaching me a lot of things about GDPR. Let me pull up my slides over here and share my screen. I also just wanted to take this opportunity to thank you guys for having me at this at the Congress. You know, I wish it could have been in person, but maybe next time it will be, and then I can participate and see everyone. I did visit Turkey once, and I would love to do that again. Perfect. Are my slides on now?
Perfectly. Thank you.
All right. So as Sevi mentioned, I'll give a brief overview of the data protection laws as they apply in the United States. What we will do is, first a disclaimer. The opinions that I mentioned over here are my own and not those of my firm or my clients. What I'm talking about right now is not considered legal advice. Let's start with an overview of how the laws in the United States function. And, you know, there are federal laws and then there's state laws. In the United States, federal law takes precedence over state law. This is enshrined in the Constitution. So the little diagram over here shows the hierarchy of the laws in this way. So it's federal law, the state laws come after that, and then some municipalities may have specific laws, and we see sometimes larger cities like Chicago or New York come up with some laws that affect some areas of the law. So at the outset, you know, we will say that in the United States, there is no specifically designed law that covers data protection, specifically healthcare data protection. In clinical trials, what ends up happening is there's a patchwork of federal laws that provide the needed protection of the data. There are some state laws that provide some additional protection, but even with the federal law and the state law, there are some gaps that remain, and we will discuss how that works and about some of those gaps in a little bit. This is more or less the outline of what we'll talk about. The main law that's relevant for data protection in clinical trials is HIPAA, the Health Insurance Portability and Accountability Act, that was passed in 1996. That was updated in 2009 by what's called the high-tech law. There are some other federal laws that apply to this general space, and then, as I said, some state laws that also help fill some of the gaps. The presentation will mostly talk about the HIPAA law because there is several provisions in that are very relevant to data protection in clinical trials in the United States. Okay, so HIPAA, when it was first enacted, it was meant to facilitate the transmittal of electronic data, electronic health information between different parties. And what it did was it standardized the way that this health data would be sent. Most of the data that would be sent around would be for payment. So healthcare plans and providers would send this healthcare data back and forth. And that standardized data was, because it would be standardized all over the country, the idea was that we should have some way of protecting this data from breaches or from other unauthorized access and use. So because of that, HIPAA came around and all the privacy provisions. There are two main rules. The privacy rule that requires that covered entities, entities that are covered under HIPAA, maintain privacy on all identifiable patient information. And then the security rule that requires that all electronic patient information is kept in a secure and safeguarded environment. If you don't take away anything from this presentation, just take this. HIPAA applies to entities, not directly to data. So if you want to track who's covered, what kind of data is covered, the first thing that you have to do, and this is where our analysis also starts when clients come to us, is are you a covered entity? And if you are, then there would be specific, specific criteria that we would look at the kind of data that you're using, and go from there. HIPAA also applies to business associates of covered entities. There are some ways that they apply directly, but usually what happens is business associates make or execute agreements with covered entities. Those are called business associate agreements. And in those contracts, the protected health information that is going to be shared is discussed. The safeguards and the commitments to safeguard and maintain privacy of this data is then. So there are only three types of covered entities: the health plans, healthcare clearinghouses, and healthcare providers that are using or disclosing protected health information in standard transactions. So standard transaction, that's what I talked about, the standard form of protected health information. Healthcare clearinghouses are not really relevant for our purposes, but they just help transmit and translate data between healthcare plans and healthcare providers. Business associates, I gave some examples over here. If you have IT support, if you have someone who's a company that's shredding your documents and they need to take those protected health information from you and then shred them, those would be your business associates. They're the service providers. They provide services or other functions for covered entities. Let's look at it in the context of a clinical trial. You have your sponsor, the pharmaceutical company. They usually work through a CRO, especially for international research, which has multiple sites, as I've shown over here. So there's a CRO, there's several sites that have researchers. Researchers also treat the patients. They have medical personnel over there. And then you have the subjects. The researchers may have their own vendors that take patient labs, maybe, they have consultants and that sort of thing that subcontract with these clinical trials. So the question over here is, within the clinical trial structure, are there any covered entities that live over here? When you come down to it, it turns out that it's really only the researchers, the clinical sites that are covered entities. Their subcontractors are, generally speaking, business associates. Most of the vendors that use protected health information or analyze it or transmit it, those would have a business associate agreement. So because the researchers are the main ones generating this data and getting it from the subjects, the entire clinical trial space is covered under HIPAA. The CROs and the sponsors work to facilitate this kind of a HIPAA compliant research. But there may be some data that doesn't go through a clinical sites, not in this typical fashion, not in the typical clinical trial, but there may be some sponsors that are working with subjects and taking some healthcare information, even some information that you would consider very private, but not doing it in the way in a standard transaction, and so they're not a healthcare provider, so they may not end up being covered. So that data would not be protected under HIPAA. Okay, so now, well, who is covered? Let's talk about what is covered, what kind of information is covered. I talked about protected health information already in a couple of slides. So what is that actually? Protected health information is individually identifiable health information held or transmitted in any form of or medium by a covered entity or its business associate. This can be demographic information. Well, actually, what is individually identifiable health information? That is also defined in the regulation. So individually identifiable health information includes demographic information and is health information relating to an individual's health, payment for health, healthcare provision, or the health condition, and identifies or can reasonably be used to identify that individual. So I give an example over here. Patient X. If you have a name for X, that is individually identifiable health information. Their date of birth is the same. And over here, I'm giving the example of paid for heart surgery. That payment itself is also healthcare, individually identifiable healthcare information. Now, if it's not individually identifiable, if it's de-identified, then it does not fall under HIPAA. And I think this is something that tracks with EU law and probably also Turkish law, but there is a difference on how some data can be de-identified. So there's two ways under the HIPAA provisions that data can be de-identified. The regulations have a list of 18 identifiers that are included over there. Once you remove all of those, for all intents and purposes, you have de-identified data. Or you can also get an expert, a qualified technician, to look at data and give a determination that a certain data set is de-identified. Those 18 identifiers that I just mentioned, I give a few examples over here: names, address, fingerprints, and unique identifying numbers. I think there's a little bit of difference between U.S. law and GDPR on the unique identifying numbers. Usually, if there's a catch-all category, that if there are some numbers that can, as we said earlier, identify or reasonably be used to identify a particular patient and individual, then that will be considered individually identifiable data. Okay, so I told you all before that there's two main rules under HIPAA. So we'll go over the privacy rule now. The next few slides talk about the privacy rule, and then we'll touch on the security rule. It's more technical, so not really relevant for our purposes today. And then we'll talk about the rest of the laws. So the general rule of the HIPAA privacy rule is that a covered entity or its business associate does not need authorization from individuals to use their protected health information for treatment, payment, or healthcare operations. And healthcare operations are those supportive roles like, looking at data to do quality assessments, to bill a patient, those kinds of things. So it's a pretty defined and discrete list of things that do not require patient consent. Really, everything else requires a patient's written authorization. If there's, to say it in full, if a covered entity or a business associate wants to use or disclose protected health information, they need a patient's written authorization to allow to do that in most cases outside of the three that I mentioned. So the big example over here for our purposes is clinical trial research. But, there's sometimes patient databases are sold for marketing, and there's some patient assistance programs and other kinds of things that also fall in this category. Now, there are some exceptions to this rule. I note some over here. If there's some reporting that's needed for law enforcement purposes, for public health purposes. Some of these exceptions were very relevant recently for the COVID pandemic. There are some FDA required reporting, such as adverse events that that are accepted from HIPAA. The ones that we'll talk about are research exceptions. I'll talk a little bit about how patient authorization is obtained for clinical trial research, and then I'll talk about some exceptions where you don't need patient authorization. So you need individual written authorization unless an exception applies. This can be sought at the same time as informed consent is sought in a clinical trial. Generally, a treating physician or healthcare provider cannot hold back on treatment unless they get an authorization, but in a research-related context, that is allowed. So a physician can say, give us the ability to take your treatment information and put it in our research. Otherwise, we won't treat you. Within the context of that clinical trial or research, they're allowed to do that. The other thing that they do that the authorization is different in the research context is that the research subject must agree that they won't access their own data while the study is blinded. So once it's unblinded, then the patient can go in and look at their own data. Otherwise, it will affect research integrity. And then, HIPAA applies all the way through to the end, even when the results are published. A research subject may revoke their authorization at any time. And I think this is, again, true with in EU law. Once that's done, once authorization is revoked, the researcher cannot analyze or disclose the patient's, the subject, I should say, protected health information anymore. But there is a little exception. If a subject has already been treated and the results are being analyzed, the guidance from the government says that a researcher can use or disclose data only if it's necessary to preserve the integrity of the research overall, including using it within FDA approval application. So let's talk about a few exceptions. There's 2 slides of exceptions. The first one is, I think, the most important one. Reviews preparatory to research exception. The way that this is structured is if a researcher wants to just look at a lot of data from many different patients to see if one of them or a few of them are eligible to enter into our research clinical trial, that is allowed to be done without a patient authorization if certain criteria are met. Firstly, the researcher must represent in writing, ideally in writing, that this PHI, the protected health information, is necessary for the research, and use and disclosure of this is needed to prepare a research protocol or do other similar functions to come up with a research. And more importantly, that no PHI will be removed from the covered entity. So usually what happens is some research associates go into the facility of the covered entity and just review the documents over there, and they cannot take any out over here, anything out from there. In fact, they cannot even get in touch with patients if there are some patients that would be really good for their study. It's the covered entity that has to go on and do that. The other exception is if an IRB waives, this is a more rare exception, but if an IRB waives need for authorization because they see that the use or disclosure of PHI will not affect privacy, there's a minimal risk of privacy, and the research cannot be conducted without the waiver. So this usually happens for retrospective studies. If someone wants to go into hospital data, find some, do some statistical analysis and find some historical, do some historical research of that kind. There is another exception if there's a limited data set where certain identifiers are not available. That usually is accepted, can be accepted, but there has to be a data use agreement that's signed between the covered entity and the research associate on some restrictions. And finally, if there's decedent's information that's being researched, that is accepted from HIPAA coverage. Okay, so let's talk about the security rule. As I said, the basic purpose of the security rule is to secure electronic PHI using reasonable and appropriate measures. This rule was passed to prevent the unauthorized access or alteration or transmittal of data. So the rule pretty much provides a whole lot of standards and specifications, technical standards and specifications, the kind of physical safeguards, the technical, administrative, organizational safeguards that you should have, and then talks about the policies and procedures that are required to maintain these safeguards. So that's all I'll say about the security rule. We'll touch a little bit on the High-Tech Act also. I mentioned earlier that in 2009, HIPAA was updated to address some gaps in the original law. The most important one, I have a few points over here, but the most important one is that there is a requirement to notify the government if a breach was, if a breach happened in a covered entity. For breaches that affected more than 500 individuals, the expectation is, or the requirement is that the government and the individuals themselves and the media are notified immediately if possible, but no more than 60 days after the discovery of the breach. Smaller breaches don't have a timeline, but also have to be reported to the government. And then there's some additional provisions on access to electronic health records by the patients themselves. So I'll mention two other federal laws. That was really what HIPAA is. There's two other federal laws that we can talk about. The Wiretap Act is sometimes used in these circumstances. The Wiretap Act prohibits the interception, use, or disclosures of electronic communication. Anything that happens over the wire, like telephones, emails, oral communication, when it's made, when it's transmitted, and where it's stored. So usually what happens in a clinical trial context, that entities obtain consent before they record any audio, video for their research. Federal Trade Commission in the United States had some laws, has maintained some laws for international transfer of clinical trial data. I think this is more, this one is specifically made for the transfer between the EU and the US, but both the Safe Harbor framework and its substitute, the Privacy Shield framework, were recently, in the last few years, invalidated by the European Court of Justice, so they don't apply. Thibault talked about this a little bit, about how the European Data Protection Board, and actually Jérémie also mentioned this, the European Data Protection Board has some additional requirements if data has to come to the United States, but most of those requirements sit in the European Union, again, because that's the higher requirement of the two. Okay, finally, I think that we are in the last couple of slides over here. State data protection laws come in and fill some of the gaps. HIPAA, in its own words, says that it's a floor, not a ceiling. So if a state puts a law in that's more stringent than the federal law, it's not preempted. So that is allowed. You can add some more rules and regulations in your particular state. So some states have taken this up. and put some laws. So, for example, California has a law called the CMIA. It allows, HIPAA only gives fines if there are breaches, unauthorized use of PHI, but in California, you're allowed to sue a covered entity if there is this kind of unauthorized use. There are some data privacy laws in specific states, but most of them do not cover health information, and so they're not as relevant. Folks over in Turkey and the EU might have heard of California's recent law, the CCPA, the California Consumer Privacy Act, that was modeled on the GDPR and actually specifically is designed to cover data, but it explicitly exempts research data. So again, it's not as applicable over here. What we do find applicable are some recent laws on genetic privacy that add to the overall structure. HIPAA covers genetic data, but only if it's used by a covered entity in a standard transaction or used or disclosed. There are some other laws in every state on breach notification and identity theft. So sometimes, criminalizing these in particular states, you see that there's you see that those apply on top of the federal law. So really, in conclusion, I'll say that there's a patchwork. I talked about a patchwork of federal laws that provide some protection of clinical trial data. HIPAA is the one that applies most because it's federal law, but it only applies to covered entities and, covered entities anywhere. And then if you have subjects in any particular state, it's always a good idea to check the particular laws to see if there's any additional requirements. So thank you again for giving me this opportunity, Sevi and Alif and all of you. Hope you have a good rest of the conference and we can take some questions, I guess. Oh, you're on mute, I think.
Thank you very much, Faraz. This was really mind-opening, and I realized how little I know about the US law with your presentation. And I think the audience, after listening all those presentations, now started to think why it is good to involve a lawyer in designing a clinical trial from very at the beginning of all procedures, and a case-by-case will be required in each trial, because the data we are going to touch upon, the process, the parties involved, the data flow methods among the parties, change the legal assessments and the risk assessments. That's very clear as a summary of our talks. And we have a lot of questions, and I have a lot of questions, but please feel free to jump in or add any comments to those ones. Unfortunately, it's not possible to address all of them, but now I started to think that we need to repeat this in person in Istanbul with a more extensive program, so that we can go in further details and have a chance to get together with the industry stakeholders face to face. And I will be bringing this idea to the Clinical Trials Association for a more data protection and clinical trials focused event. Okay, let's start with some of the questions. Actually, the consent, withdrawal of the consent is an important area and creates a lot of confusion in practice. What is your advice to your clients when they come across with a withdrawal situation by a volunteer? Will it be, if it is not an only case in a trial, would you see a risk of not, the defamation of the, outcome of the trial data, etc.? I would like to hear all of your thoughts about the withdrawal procedures and your not subjective legal advice, but opinions on a broad scale. Jérémie, would you like to?
Yes, I can start.
Question?
Yeah, as I mentioned, the withdrawal of the consent is a right of any data subject who has accepted that his personal data be processed on the basis of the consent. So it's not possible to restrict in any way the possibility to withdraw the consent. And it's true that in practice, it could have significant impact on some clinical trial results if several persons withdraw their consent, and particularly if the number of participants is reduced, this can obviously impact the results of the clinical trial, which is a little bit difficult. I would just highlight two things. One is that the withdrawal of the consent will only relate to the processing of the personal data as from the moment the consent is withdrawn. So, of course, it will not jeopardize the processing activities before the withdrawal of the consent. And two, unless I'm mistaken, there are not a lot of withdrawal of consent specific to the processing of personal data. So I do not think that someone will only withdraw their consent to the processing of their personal data. It will probably come together with a withdrawal from the clinical trial. So I don't know if in practice it's really that an issue. Maybe Thibaut has another experience about that, but I do not think that there has been significant issues with the withdrawal in practice, but it could. So my advice would be that the sponsors really think at the very beginning of the clinical trial on which legal grounds he will process the personal data, because if he thinks that there could be an impact if there are too many withdrawals, then he should carefully consider if there are no other alternatives than the consent for the processing of personal data, because as Thibaut rightfully highlighted, there is still the ethics consent that is important.
Thank you very much. Thibaut,
Yeah.
Would you like to add anything, or?
I can just concur and maybe add, as Jérémie said, the issues that we see are often caused by confusion rather than there's an unclear legal situation, because as he said, withdrawing consent from a data protection perspective only counts for the future. So to avoid confusion, I think it's two things there. First, it's important to have clear information for the data subject, that they know if they withdraw consent, and if that's consent to participate or data protection consent, what will be the consequences of that consent. Sometimes data subjects are also confused about the rights that they have under data protection, and they may say, I don't want you to process my personal data, but I want to stay in the trial. And then you have to come back to them and explain that's not possible, because we need to process your personal data for you to stay in this trial. And the other is this confusion that's caused by using consent, both the regulatory consent and data protection consent, what I mentioned in my presentation. And that's, I think, one of the reasons maybe not to opt for consent as a legal basis, but see if there's anything else, because you can avoid that whole confusing situation. Because, and that's something else that Jérémie mentioned in his presentation, you cannot switch the legal basis after you've asked consent and somebody wants to revoke that consent. You cannot say, well, we have another option as a legal basis anyway, so we didn't need your consent in the first place. Once that you've chosen consent as the legal basis and you've asked consent for the processing of personal data, it would be misleading to then later use another legal basis. So good preparation and transparency will be very important there.
Mm-hmm. And Faraz, I would like to ask you at that point, the US law seems quite complicated in terms of consent and data processing requirements, and the variety of different legislation interacts. Actually, even the wiretapping legislation has an effect on your the processing activity designing and consent requirements. So when you are representing a company in the US who would like to conduct clinical trials outside of the US, What are the basic considerations you take into account to manage compliance with, data protection legislation in abroad, like the GDPR and in different countries? What is the first step for you?
Yeah, so, usually we've seen research trials by US companies occur, a large part in the EU, Australia. There's many countries that have very significant data protection regimes and laws and regulations. So usually what our clients do is just have, separate compliance frameworks for each jurisdiction, because we know that the US, the HIPAA regime may not apply in other places. So, because it's not territory based, because it's not data based as the GDPR, it's only covered entity based. If there's a international trial and there are some research subjects in the EU, that those laws will apply, especially if the site and the research investigators themselves are from the EU, which is most usually the case. If it's a US covered entity that is doing research internationally over there, maybe in that issue, the law hasn't been settled on that, but it's most likely that people who are foreign will still have HIPAA applied to them, because it's a US based covered entity that is doing that research wherever they are. So usually what we counsel clients is to get both local lawyers, local counsel, and local investigators to do that, those kinds of to have those kinds of questions.
And taking from here, I would like to return to Europe again. And you have mentioned, both of you, in your presentations that in case a company decides to perform a clinical trial in the EU, undoubtedly the GDPR will be applied. But what if an EU citizen comes to, let's say, Turkey, and join a clinical trial as a volunteer? Because we, in some cases, for accessing, unmet medical needs, some people from EU citizens would like to join trials in Turkey or in other jurisdictions. In that case, if the data generated from this trial to be used for let's say, a product to be commercialized in Europe in future, and would it make any difference? And if from this EU citizens, only one person's perspective, the parties will require to be comply with GDPR or not, or only the Turkish data protections rule will apply?
I think that only Turkish rules will apply, because it's not really the citizenship that governs the protection of personal data. I do not think that if an EU person goes to the US or to Turkey or anywhere else, if the processing activities are strictly located outside of the EU, unless I'm mistaken, I don't think that the GDPR will apply. But Thibaut, correct me if I'm wrong. On the contrary, if a Turkish or a US citizen comes in the EU, in that case, the GDPR will apply to that processing activity.
Mm-hmm. Yes, I totally agree with that. It's the citizenship is not relevant. So unless the sponsor would be established in the EU, then it could be a different situation. But if it's a purely Turkish affair, the fact that there is a European citizen taking part, or that the product will come on the market in the EU, is not relevant.
Okay, thank you very much. And Jérémie, in your presentation, you have mentioned the new developments on clinical trials information system, and it's a new system, an online approval system. Will that system create any problems for management of different needs of different countries in terms of data protection? Will it be possible to get approval in different consent forms to be applied in different European countries? throughout the system?
Yeah, I'm not a regulatory expert, but I think that the system has been built to comply with the data protection principles and obligations of the GDPR, and the purpose is to have an harmonized approach between the member states. So I think that when using that platform, there should not be any specifics between the different member states and the different countries. But of course, non-EU sponsors that will carry out clinical trials in Europe will have to use that tool, and we have to become familiar with that tool. So there is a need to learn that tool, and I think it's also the case for the EU entities because it's a very brand new platform. But in principle, it has been built, and I think that it took a long time to make it real because of the different security, data security, and data protection considerations.
Maybe adding to that something which I touched upon in my presentation, because the CTIS does a lot of different things, but one of the innovative features is that it provides a one-stop shop for submitting or requesting approval, and that will go to ethics committees and regulatory authorities. But I think it's important that for like confirmations of informed consent form is something that I mentioned, you will still need national consent forms because they contain the contact details of the local hospital. And so those will still be reviewed. There's a national path where they will be reviewed by the national authorities and ethics committees. So you can still have that situations to which I mentioned that there's an authority in one country that has issues with the chosen legal basis. So ideally, it would have provided more harmonization, but I'm not entirely sure that it will.
And one final question to all of you. Some people believe that all these regulations in data protection restricts the implementation of clinical research and eliminates, numbers of the, let's say, research and development activities, and because they lead extra obligations on the individual investigators. We are not always talking about big companies having proper sources to manage those, but there are sometimes investigators initiates clinical trials with carrying all these burdens. So do you think that those regulations really negatively affects on the clinical trial area and the number of trials? Do you see a reduce in the research and development activities? Just an insight. I know you don't have the numbers. We none of us have. Do you think that has a positive effect or a negative effect on the performance of the trials? Faraz, let's start with your opinion.
Yeah, sure. No, I'm happy to take this. Sure, there may have been, when these rules came out, at least in the United States over 20 years ago, there may have been researchers that found the burden a bit too much and decided that they don't want to participate. I think it's rare that if there's some good product, there are so many other regulations that they also have to go through, both in the EU and the US, to get that drug approved. For the public safety, to make sure that these products are efficacious and safe. The governments and different regulatory authorities require a high burden be met. So I think the privacy part of it may have deterred someone, but I don't think in any significant manner. I think if anything, it could have increased the number of people who are increase the number of participants who are interested in becoming part of a clinical trial, because they have seen that there is enough protections of that data, that they know that they have the right to revoke their authorization, their consent at any point. So I think overall, it creates a system where the research participants understand where the information is going to go. In today's world, where with a click of a button, you can send, the information of billions, millions and millions of people across the world in a second. I think laws like this make people, research participants, a little bit more willing to participate in the research. So I think overall, these provide a very important and so positive impact, I think, in the industry and overall in research and development.
Is there any opposing opinion from Europe?
Thibaut, maybe you can start if you want, or just let me if you want to start, and I can continue.
Yeah, I don't have much to say. I don't have the numbers. The only thing I can say, I think, if again, the issues of the lack of harmonization on some points and the differences between member states, I think if a lot of that is unnecessary, and if that would go away, I think nobody would be sad.
Yeah, for me, I think that the new regulations have positive sides and negative sides. Maybe the positive side is that there is a greater harmonization compared to the regime under the directive, even if actually 90% of the rules of the GDPR already existed before the GDPR. So in principle, everyone should be used to those rules since the 90s, but when there was no sanctions, no one cared about that. So that's, I think, a positive sign. Also, the better protection for the patients maybe brings more trust from the patient as well for the processing of their personal data. But yes, negative side, as mentioned by Thibaut, there is still specific rules in some countries which must be taken into account. This is not easy. It's not convenient to have a consistent approach. It's difficult, but I would say that as a general rule, the life sciences sector is usually used to protect the personal data of the patient. So I think that it's more new rules and a new framework to become familiar with, but the fact to handle, to process health-related data has always been, I think, been protected by pharmaceutical companies for a long time because they know that it's important. Very often it's a person with a disease, so it's important to protect them, and also with the medical secrecy behind the processing of personal data. I think that, okay, there are new rules, there are some obstacles that we have to address, but overall, I think that it's quite positive in general.
I agree, actually. I think the rules provided for the benefit of all should be regarded and welcomed. At the end, they will be working for the health of everyone and the safety of everyone. Thank you very much. That was really joyful, and I've learned a lot from all presentations, and that was a very nice opportunity to collect all of you together. I hope you also enjoyed participating in, and with my promise for taking this issue further with a face-to-face event in the next year, hopefully in Turkey, I would like to close the session.